Do this one.
Good morning to Monday morning, February 28th, in this third week of the budget session. The time is 8:01. We are starting the Senate Judiciary Committee, and we'll start with roll call.
Senator Cooper.
Here.
Senator French.
Here.
Senator Kolb.
Present.
Senator Cost.
Here.
Chairwoman Nethercott.
Here. Well, we are here bright and early and starting on time. That must be a good indication for how this week might go for us. We're also doing, for our morning's agenda, the majority of these bills come from the Joint Judiciary's work in the interim, so the committee is familiar with them. There is one bill, House Bill 86, Genetic Data Privacy Amendments, which is from the Select Committee on Blockchain, Financial Technology and Digital Innovation. I serve on that committee as well, so I will present that bill for the committee. But to start off with, we have House Bill 39, Pre-Application Determinations for Licensing. Good members of the committee, I'm going to call on one of you to explain this bill since you are familiar with it. Do I have a volunteer? Senator Cooper, thank you for volunteering.
Let me figure out what it says here real quick. That's not what it is.
It's the wrong date.
It is. Thank you.
And do I have anyone in the room that wants to testify on this bill? Wonderful. Either one of you can come on forward first and we'll get you started here up on deck. Looks like we have some guests with us here this morning. Welcome. Everybody come get some coffee. It's gonna go kind of unusually quiet on this Monday morning. Are you ready, Senator Cooper? You want some backup?
Yes, I need some backup.
All right, so I'll go ahead and explain this bill for the committee, but Senator Cooper, you will explain this bill on the floor.
Okay, I'm listening.
All right. So House Bill 39, Pre-Application Determination for Licensing. If you recall, good members of the committee, we heard from the Council of State Governments and a number of committee members about the need to maybe reduce the limitations associated with licensure for a number of occupations, particularly as it relates to the pre-application process, to understand before applying and going through the process of having to apply and pay for that with a license to actually get or go through the schooling associated with that licensure to get a pre-application determination. So does that criminal conviction maybe prohibit you from ultimately getting that license? And so should you pick that degree or different type of program before you go down that pathway? So we can look, really all of the underlying portions of the bill draft would be new language in our statute. So we can start on page 2. We authorize that any professional licensing board, and those are listed in our statutes too, and there are many licensing boards in our state, have the authority to receive criminal history record information. This committee has heard in the past that criminal history record information is limited for who can receive that, and it can only be statutorily authorized as a result of the sensitivity associated with that information. And so on page 2, lines 8 through 13, we provide that authority to all professional licensing boards. And so going down on page 2, this is the section dealing with considering criminal convictions for pre-application determinations. So any person who has been previously convicted of a crime may at any time apply to a board. And moving along to just summarize it. For a determination, we're going on to page 3, line 2, for a determination as to whether one or more of the person's criminal convictions will prevent the person from receiving a license, certification, or registration. And each board has authority and by rule established a procedure for how an application is to be submitted and reviewed. Going down on the bottom of page 3, starting on line 13, there's a new sentence there. The board, commission, or commissioner authority may by rule establish any charge and charge a reasonable fee to recover the costs of researching and developing a determination under this subsection. Any fee shall not exceed the cost of providing the determination under this section. And here's some pretty important language that we discussed in the interim as well, starting on lines 19 through 21. A determination made by a board, commission, commissioner, or authority under this subsection shall not be binding upon the board, commission, commissioner, or authority. And so with that, good committee members, are there questions and recollections of our memories associated with this bill? Seeing none, there is a fiscal note here from our Department of Family Services, and I think a member of that agency maybe who provided that fiscal note is here. Looks like they're requesting, the Board of Medicine estimates 12 applications per year and a fee of $75 for an estimated annual increase in special revenue of $900. They anticipate additional one-time expenses within the standard budget of roughly $9,000 to develop an online form to accept requests. So we'll take note of that. And then this next one is for House Bill 37. So that is it for the bill. All right, committee will go to public comment at this time. Welcome.
Thank you, Madam Chairwoman. Thank you, members of the committee. My name is Nick Rothschadel. I am the General Counsel of the Division of Banking. I will make just a few comments here, and we have one item to raise about this particular bill. As you probably know, the Commissioner of the Division of Banking licenses and regulates money transmitters under Title 40, Chapter 22. This bill appears to allow a person previously convicted of a crime to apply to the Division of Banking for a determination as to whether the conviction may prevent the person from receiving a money transmitter license. The division has no concerns with the bill, but did want to raise this one point. I will direct you to lines 22 to 23 of page 2. This language on 22 to 23 refers to a profession or occupation regulated under this title or under, and then it proceeds to cross-reference various statutory provisions. This includes on page 3, line 2, the bill cross-references 40-22-109, a provision in the Wyoming Money Transmitters Act. The division believes that 40-22-109 is not the ideal cross-reference in this particular instance. 40-22-109 is a provision of the Wyoming Money Transmitters Act that deals with the application fee paid for a money transmitter license. If the intent is to identify a single provision under which money transmitters are regulated, the division believes it would be appropriate to reference 40-22-103, which establishes that a person shall not engage in the business of money transmission without a license, and that the division regulates money transmitters and carries out the Wyoming Money Transmitters Act. Now, I think we understand what's trying to be accomplished, even with the current citation, but we do think it would be an improvement to switch from 109 to 103. And with that, I will stand for any questions. Thank you.
Well, thank you for your close attention to that detail. I think you're correct that statutory change needs to be made. Questions for the Division of Banking? I have a question, Mr. Rochelle. What type of convictions would somebody be prevented from receiving a money transmitter license? Prepared lawyer.
Thank you for the question, Madam Chairwoman. It is a bit of a case-by-case basis because the standard under which the Commissioner of the Division of Banking grants a license is that the applicant's business will be conducted honestly, fairly, and in a manner commanding the confidence and trust of the community. So that does grant the Commissioner a significant amount of discretion. However, typically the types of convictions that would be relevant would be related to money transmission itself, or financial crime, or fraud, or deceit, that type of conviction.
All right, thank you. Further questions? All right, seeing none, appreciate your time here today. Really appreciate that catch. Further public comment? Welcome, good morning.
Madam Chairman, Senators, my name is Kevin Bonenblust. I'm the Executive Director of the State Board of Medicine, and appreciate the opportunity to meet with you, and I'll address that fiscal note. I would tell you that you might recall from the interim, there was a discussion, several licensing boards said, this is the sort of thing we actually do all the time, or with some frequency. And so in some ways, this was a little bit of a solution in search of a problem. However, certainly from the Board of Medicine's perspective, we appreciate the changes that have taken place in the bill. It's very workable for us. It'll sort of codify what we already do, because we do get those inquiries with some frequency. You know, will this conviction keep me from getting licensed in Wyoming? But overall, we appreciate the work the committee did on the bill, and really have no difficulty with it, so appreciate that very much. But also would note, as far as the fiscal note, we've continued to look at it, because at one point when this was going to be a binding determination on the board, we wanted to be able to include this in our database so that when we actually perhaps got an application from the individual, we'd be able to say, oh yes, this was the determination that was made, we'd match them up and everything else. We've looked at it further. We found we can probably take care of it without any kind of fiscal expenditure. That's what we told the House side during their hearing. And so at this point, the House did not refer it to appropriations, and we don't feel the need that it needs to go to appropriations on this side either, unless you feel otherwise. So with that, I'd be happy to answer any questions. But again, as noted, the changes that have been made to the bill from what was first introduced, very workable from the Board of Medicine's perspective.
All right, thank you, Mr. Bonenblust. Appreciate you being here again and being with us in the interim. Questions from the committee members? Senator Cooper.
Thank you, Madam Chairman. Same basic question, sir. Could you tell me roughly who is covered under the licensing of the medical board, and what kind of crimes would be looked at?
Madam Chairman, Senator Cooper, the Board of Medicine licenses physicians, so that'd be MDs and DOs plus physician assistants, but has a lot of similarities to the other healthcare licensing boards. And what we would look for certainly is that, and I should rewind a little bit, about 12 years ago, we changed the Medical Practice Act, because it used to be any criminal conviction was an absolute bar to licensure. We asked the legislature to dial that back and say that it could be grounds for denial, but was not an absolute bar, because we had some people that, you call it youthful indiscretions, things that happened out behind a bar during frontier days when somebody was 21 years old, and you don't want to bar them from being a physician in your state when they've cleaned up their act and they're outstanding. And so what our board would look at would be obviously those that relate to trust, and any kind of sexual misconduct, things like that, that would compromise the relationship between the physician and the patient. Of course, in this day and age also, because of the rife fraud that's out there in healthcare, somebody was convicted of a crime of trust like that, where it was a financial crime, that might be a reason for it as well. But it's really, we look at it through the lens of, does this affect the ability to safely practice? Not just, you have a criminal conviction, all right, then you're out. So it's pretty selective.
Senator Cost, question? Follow-up, Senator Cooper?
Yes, ma'am. Thank you, Madam Chair. Nursing is not included in this then?
Madam Chairman, actually, Board of Nursing is, I can't speak for them, but because they fall under Title 33, they fall under that large umbrella that's covered by this bill.
Senator Kolb?
Thank you, Madam Chairman. I guess, would you characterize this as a preliminary check on your background information to be used further in the future, so it would kind of save you a step when they say would further apply after they made these other qualifications?
Mr. Bonenblust?
Madam Chairman, Senator Kolb, I think it would be to a degree. I think what we would do, though, is if somebody had gone through this process and we had found, yes, there was a criminal conviction, but no, there's no other issues, we probably would then want to run another criminal background check at the time of the application, just because things happen, to put it nicely. And so given how much takes place in a medical licensing application, that really wouldn't slow things. DCI has been very quick about turning those around for us. So that would not be something that would really impede licensure for us if they did choose to apply then at a later date.
Thank you.
All right, Senator Cost.
Thank you, Madam Chair. With regards to drugs, and especially doctors, how do you see that going as far as in the pre?
Madam Chairman, Senator Cost, that's going to be a difficult one. It's going to be, is it personal use? Is it that sort of thing? Is it something that, again, youthful indiscretion? Or is it more of a distribution? Because, once you become a licensed physician or PA, you sort of have the key to the closet, if you will, with that license or that prescription pad. So that would be a matter of sort of gauging it. And that's where sort of the art comes into it. It's not just a hard science, yes or no. You look at what it really entailed.
All right, final questions, committee? All right, seeing none, thank you for being here.
Thank you, Madam Chair.
Further public comment? We'll acknowledge that Ms. Chambers from the Attorney General's Office, Division of Criminal Investigation, who receives these criminal histories, is present with us. So if you have questions for her, committee members, are you good? All right, we won't call you up, Ms. Chambers. All right, it is a Monday, the committee. Further public comment? All right, seeing none, public comment is closed. Anybody online? All right. I really don't get to know that. I don't see who is online providing public comment or whether or not they're raising their hand. I have no idea. Just a side note. All right. Our public comment is closed. Committee, back to you. Moved by Cost. Seconded by Kolb. Is there amendment, Senator Cooper?
I'd like to move amendment. Change the language on page 3, line 2 from the statute 40-22-109 to 40-22-103.
Moved by Senator Cooper, seconded by Senator Cost. We have that correct statutory citation? 103? All right. Further discussion? All right, seeing none, roll call.
Senator Cooper,
What's that?
Aye.
Senator French,
No, I'm sorry, did I not call roll?
yeah,
All in favor of Senator Cooper's amendment, please say aye.
Aye.
Any opposed? Roll call vote on the bill.
let's try this again. Senator Cooper,
Aye.
Senator French. Senator Kolb,
Aye.
Senator Cost,
Aye.
Chairman Nethercott.
Aye.
Madam Chair, House Bill 39 passes as amended with 4 ayes and 1 no.
All right, thank you. With that, we will go to House Bill 37, Juvenile Justice Data Reporting. Senator Kolb, can you walk us through this bill?
Thank you, Madam Chairman. I will do my best to recall what we learned about this last summer.
Of note, the bill in your folder is green. And if you look at the top right corner of the bill, it says engrossed. And that means that the bill has been amended from the House. And so the bill is in process. I won't ask you to know what those amendments were, but that is something for the committee's consideration, that the bill has been amended from its original form from the Joint Judiciary Committee's work. So with that, Senator Kolb, go ahead.
This bill is a act relating to criminal history records, transferring the responsibility for the Juvenile Justice Information System to the Department of Family Services, and requiring the Department of Family Services to standardize the collection of this information, amending reporting requirements, and providing appropriations, requiring rulemaking and requiring a report, and providing an effective date. The need for this bill was brought up, frankly, because of the problem with records and not having the data that was needed to make any decisions about what to be done of juvenile justice situations. And that's the beginning of this bill. And this is a way of standardizing the information collection and then having it located in one area to get a report on just what is going on with our juvenile justice system, and maybe pointing out things that we would need to address once we had the data. Madam Chairman.
Thank you, Senator Kolb. Questions from the committee for Senator Kolb? All right, seeing none. Public comment? All right. Senator Kolb, do you see an agency estimate or administrative impact in your packet?
I do, Madam Chair.
It would be on the white page right here.
Oh, well, that's the reason why I didn't see it right away.
And so you can see on that sheet that's in your folder packet on the top right-hand corner, it says 2022 House Bill 37. This is submitted by the Department of Family Services.
And would you want me to go through this?
No,
Madam
I
Chair?
think we have the Department of Family Services here with us this morning who can help walk us through their agency impact. So welcome, Director Schmidt. Good to see you this morning.
Thank you, Madam Chairwoman. My name is Corinne Schmidt. I'm the Director of the Department of Family Services, and we're glad to be here as well. So, Madam Chairwoman, Senator Kolb, you'll see the fiscal impact statement, which is what we prepared prior to the bill being heard in the House side. However, that didn't come to the attention of the committee. So the House, Representative Swanitzer on the floor of the House brought another amendment to be able to add some additional dollars to our budget. And the reason for the additional dollars is twofold. One, we don't have the current capacity to do any of the analysis of the data. So we will, if this bill were to go through without that particular position, we would be collecting a lot of data but not have a resource to do anything with that data. So the policy analyst is an important component of looking at the research side, which is a big part of why this bill is being passed. The second part of the fiscal impact is really to help our system, which right now the budget for our system is only looking at those federal requirements that we have to report to the feds to do our case management. The addition of these dollars will help us configure the system to be able to add information outside of what we would normally collect. What that essentially means is the connections to the circuit court that we would need to have to collect that data. Currently, the system that we're proposing and that was funded in the budget bill is strictly for those cases that we serve, which are Child Protective Services cases, CHINS, Child in Need of Supervision cases, and juvenile delinquent cases as they come in via Title 14. So that leaves a lot of circuit court cases not being collected in the current design of the system. These dollars would allow us to configure the proposed system to collect the circuit court data.
And Director, if you can, maybe help the committee understand the scope of that circuit court data, recognizing I don't know that we have good juvenile justice data, but do we know how voluminous those records may be? How many juveniles are going through the circuit courts? Do we have a sense of that?
Madam Chairwoman, members of the committee, not necessarily, which is one of the reasons for this bill. It really is to pull in the data that we don't normally collect so that we can make some determinations about how many youth are coming into the system, what's the disposition of those youth coming into the system, and then potentially being able to track outcomes of those youth over time. A big component of this bill and the inclusion of the circuit court data is really to get at some of the diversion programs that are out there. Certainly there is an amendment to the budget bill asking for the reinstatement of funding of community juvenile service boards. It's also through that process we'll be able to collect more data. The data that they collect does not necessarily come into the DFS system because they're not serving just DFS kids.
Committee members, as the Joint Judiciary members, can anybody tell me how many circuit courts there are in Wyoming? All right. Senator French, go ahead.
No.
You don't have to answer that question, but you can.
No, I could take a guess, but no, I do not know that. I have another question.
Go ahead, Senator French.
Thank you, Madam Chair. Can you expand on that, on the fiscal note, the contractual service services costs. Year 23, 350,000, 24, 100,000. Do you do a
We're gonna-
RFP? And who do you generally
Can't Google.
go to, and who decide?
No Googling.
Is it you that decides if 4 people respond to an RFP, do you decide that? Who decides that?
Director?
Madam Chairwoman, Senator French, I'm going to let Lindsay Schilling explain the RFP process that we've already gone through for our case management system.
Oh, okay.
Good morning, Madam Chairman, Senator French. My name is Lindsay Schilling. I'm the Senior Administrator with the Social Services Division. And we have actually been working since about 2016 through the procurement process for a new case management system. We did go through a competitive RFP last summer. We had 14 local and national IT companies bid on that project, and through an evaluation process have selected a vendor. So these costs would just be adding additional scope to that current contract and additional requirements to collect data that we would need to comply with this.
Follow
Follow up.
up. Thank you, Madam Chair. So you already have a vendor in place. This is just for them to address the additional data that comes in if this bill passes.
Ms. Schilling?
Madam Chair, Senator French, that's correct. We're just finalizing the contract negotiation piece with that entity now. So this would be included in that.
Any further thoughts about county courts in the state of Wyoming that became circuit courts? 23. So the Department of Family Services would be collecting data from all of the district courts in the state of Wyoming and all of the circuit courts in the state of Wyoming. Does the committee recall that we discussed municipal courts as well? Does the bill address municipal courts? Director Schmidt, do you know?
Madam Chairwoman, no, this bill does not address municipal courts. And as we discussed during the interim, the municipal courts are quite unwieldy in terms of their numbers and how they operate. I think the best plan is to first start bringing in the circuit court data. And then as we start to standardize that data collection, then we can start having conversations with municipal courts as appropriate and looking to see how we can bring that data in. One of the benefits of the circuit court data is that it also goes through the Supreme Court, so it makes it easier to be able for us to collect it and to connect to the circuit court or the Supreme Court's data system. However, with municipal court, there's no one standard data system that we could connect to.
Senator French.
Thank you, Madam Chair. Aren't the municipal courts a major part of the data that's missing?
Director?
Madam Chairwoman, Senator French, yes, we believe that there are a substantial, substantial is probably an overstatement. There's a good percentage of youth who come into municipal courts on violations of city ordinances, which is different than state law. So it'll depend on the ordinance and then the violation. Do I think that that data is worth collecting? Yes, I do. We're just not at a place right now where that would be feasible.
Senator Cost.
Thank you, Madam Chair. Director, do you have any kind of an estimate of what it would take to make that feasible?
Director?
Madam Chairwoman, Senator Cost, no. Anything I'd offer would just be a wag.
Senator Kolb?
Thank you, Madam Chair. On the fiscal note, I guess maybe you could clarify what you might think of future funding beyond 2024. You anticipate being roughly the same amount, the 174,000. Continue.
Director?
Madam Chairwoman, Senator Kolb, yes, that 225,174 is an ongoing, and in the bill it says that it would be added to our standard budget. The additional $200 or $200,000 or so that you see in FY23 is just for that initial development of the integration of this new data. So it's just a one-time cost. After that, though, maintaining that, that cost would have to continue. Maintaining the maintenance and operations would have to be ongoing.
Clarification.
Sure, follow up.
250,000?
300. Madam Chairwoman.
50 minus 100.
Right, for Senator Kolb, if you look on the page, and these aren't numbered, but under the description, you'll see that the $250,000 under the 900 series is for the initial interface development, and then 100,000 per year for ongoing data entry system. So that's, the 250,000 is just one time, and then 100 ongoing from there on out. Did I not answer your question?
Yeah, no, you did, but I just want to clarify what you had said because you missed the 50,000. So I wanted to make sure that we were talking about the same thing. Thank you.
Yes.
That's not an issue. And one other follow-up.
Yeah, sure.
Are you in favor of the bill?
Madam Chairwoman, Senator Kolb, yes, we are in favor of this bill.
And Director Schmidt, sensing that my Joint Judiciary Committee members are forgetting the work we did in the interim and are now voting no on their joint judiciary bills when they don't hear enthusiastic support from the agencies, isn't it true, Director, so bear with me, isn't it true, Director Schmidt, that there is no juvenile justice data in the state of Wyoming that allows for the legislature to allocate resources meaningfully?
Madam Chairwoman, correct. So one of the issues that we have and that we've continually faced for a long time is trying to figure out the impact of juvenile justice on the state of Wyoming and on youth. So in our state, we have several juvenile justice systems. The one that DFS is primarily involved in is when a child or youth comes to the attention of the juvenile court, and then a petition is filed in juvenile court. And then we will either do probation or have the means for placement if necessary. However, there are a lot of youth who commit crimes at the circuit court level that would never come to the attention of the juvenile court, and we do not have a consistent way of capturing data around those youth. So what this bill really proposes to do is to give us the responsibility, which was primarily the responsibility of the Department of Criminal Investigations and the Supreme Court, and consolidates it with us so that we can, one, use our what will be our new case management system to collect extra data around those circuit court kids so that we can do a better job of analyzing what is happening with our juvenile justice population across the board, not just within the juvenile court aspect. It will take some time, but we do think that having access to all this data and being able to do analysis will then help us with better policy around incarceration, detention, and placement. There's been a lot of discussion lately about the level of confinement of youth in our care, which means we're placing a higher percentage of youth than other states. That is true. They don't all go to jail. They don't all go to incarceration, but they do go into some level of placement, whether it be in some sort of treatment setting or a group home. So I think this data will really help us to understand why that placement data is relatively high, and then also be able to develop better programming, which this is really where we think this bill is important, so that we can develop community resources. We believe that if we had a better understanding of the needs of those kids who are getting cited in circuit court, we as an agency and a state can do better to provide programming at that very local level and at that very early level and prevent a lot of youth coming into care unnecessarily. So that's the overview of why we believe this bill is so important.
Thank you, Director. Appreciate that. Senator French.
Thank you, Madam Chair. So a youth is arrested and the county attorney decides, and no, I'm not gonna follow charges, it doesn't make it to the court system. Is that data still collected that they were arrested for A, B, C, or D? Even though the other county attorney said, nah.
Director?
Madam Chairwoman, Senator French, it depends on the county attorney and what they collect. There's no requirements about what they should be collecting regularly, which is part of this bill as well. So while the statute is in place currently under DCI, there isn't a whole lot of follow-through, uniform follow-through across the state about what data is entered. So a big part of this bill is to standardize that data collection and then also to provide opportunity to work with the county attorneys in order to get the data collected and entered into the system. Does that, Senator French, answer your question?
Madam Chairman, yes and no. Yes and no. So even though it doesn't go to a court, does that information have to be reported? That John Doe or Jane Doe was arrested for whatever, but the county attorney decided, no, I'm not gonna press charges, or does that information still have to be reported? Or no, since it didn't make it to the court?
Director, if you know.
Madam Chairwoman, Senator French, I do not know. I do know the current statute collects data, but I do not recall if that data is mandatory if there's a conviction or merely a citation. I think the question you're asking is if there is no conviction, if a county attorney decides not to pursue any further action, whether that data is collected. And my hope is that the Madam Chairwoman is quickly reading the bill to see if that is the case. But
Yeah, Director, I think that's a great answer. And I think the concern that Senator French is driving at is, are we making a record for this child that they have no control over when nothing happened? And the answer to that is no. One, and I think people in the room can attest to this, that there is juvenile information is the most protected and confidential information that exists in our database of systems. It is not released, and you can see even on page 3, lines 9 through 17, jurisdiction and confidentiality of records. And this is not the only location where these records are identified as being highly confidential. And really, if you recall, the purpose of this information is I mean, I should be careful about how I say this, but the purpose of the data isn't to know individuals necessarily. It's to understand policy decisions associated with data in the aggregate, to identify where to place resources. From our level, we're not concerned with an individual child. We're concerned with the system and how it serves all of the children in Wyoming. And so that information, nobody is utilizing that information other than for those purposes, is kind of in the aggregate. So there is, and Director, tell me if I'm correct, does law enforcement have the ability to access the Department of Family Services records associated with juveniles, or does anyone else for that matter?
Madam Chairwoman, no, not unless they're part of the case. So if there's something happening with the case in juvenile court that where law enforcement may be part of the decision-making, then no, they would not be able just to pull general access from the Department of Family Services data.
Senator Kolb.
Thank you, Madam Chairwoman. Yeah, my memory's fuzzy on this, but I recall that we had conversations during the interim that was specifically around just collecting the numbers and not about individuals, because we're trying to ascertain just what is going on with the juvenile justice system and if there has to be changes in other areas. So I thought there was some conversation, and maybe you could refresh my memory if you can recall, about just how we were collecting this data. So I've read the bill, and it actually on page 8, line 8, it goes on to a circumstance where in any case in which a juvenile is convicted or adjudicated delinquent, it goes on to not dismiss charges or whatever that may be. But I thought we had a conversation. Maybe you could expound on this about maybe not identifying people by names, but identifying basically the type of issues we're facing with juveniles and just what maybe we want to do about that in the system. So we needed this information to make further decisions. Thank you, Director Schmidt.
And Director, if I may perhaps distinguish between policymakers' access to data, the role of that new position to analyze that data in your usage of the data? Distinguish who sees what and how they see it, perhaps, Director.
Sure, Madam Chairwoman, Senator Kolb. So as I mentioned at the beginning of the conversation, we have disparate juvenile justice systems. The information that's collected by the Department of Family Services per a Title 14 juvenile court case is wholly confidential. That is not information that we share with any entity outside of the parties to that case, meaning the delinquent, perhaps family, their attorneys, and the courts. Any of the proceedings under Title 14 are also confidential, meaning that no one can just walk in off the street and participate or listen to a juvenile court proceeding. So that data is data that we're already collecting, and it's already very secure, but it's also data we use for case management. So if we have a juvenile delinquent that is on our caseload, we're going to be recording data about how they're doing on their case plan. Are they fulfilling their obligations per the court order, such as a probation, doing whatever it is that the court has ordered them to do? So the system we use is a case management system, and that data will always be protected. Those laws exist right now, and these statutes don't do anything to the confidentiality statutes. What this group of data really is data that's being collected at the circuit court level, and those proceedings are actually public. So a juvenile delinquent under the circuit court case or the circuit court side is considered an adult. They don't have the same protections of confidentiality as if the case were filed in juvenile court. So there's a distinction between the two types of courts. The age really doesn't matter because in the circuit court, they see all of those cases as adults. So the data that's being collected right now is pretty much public to some respect. It's not that you can go in and mine the data, but you can sit and listen to a hearing and certainly hear all of the data yourself. What this suggests is taking that data, bringing it into a larger system where we can combine it, so to speak, with the juvenile delinquency data we have and say, let's look at these cases overall. It gives us a more complete picture of what's happening with our kids. You'll notice on page 12, lines 7, 8, 9, and 10, there was addition of language on the House side that said, gives us permission to write rules so that when that youth turns 18, we de-identify that data and then we'll have it available to us to be able to do long-term studies. So for example, if we have a kid that appears in circuit court at 18, that data becomes confidential, and then we can use that data over time to say, did that kid continue to get into trouble? Did they continue to go into the Department of Corrections, for example? What happened with that youth in aggregate, not per child? So there's a lot of things that are happening here with this juvenile justice bill, but ultimately it's taking public data, private data, giving us the opportunity to look across all that data to make some policy recommendations about how we can address our juvenile delinquencies in the state.
Further questions? So glad you're here, Director. Appreciate you. You might have saved our bill.
Thank you, Madam Chairwoman
Thank you.
and members of the committee.
All right, further public comment on this bill. Ms. Chambers, welcome.
Good morning. My name is Kara Chambers. I'm with the Attorney General's office wearing my DCI, Division of Criminal Investigation hat today. At the very least, I kind of wanted to walk you through some of the changes in the engrossed, if that's all right, mostly because we asked for one of them. If you turn to page 8 of the engrossed copy, and these were, and I'm kind of stepping on DFS's toes because some of them were at their behest and in conversation with Ms. Sheen. But if you go to line 3 on page 8, you'll see that the engrossed, what was added is the and overall compliance with this act. And that was just to make sure that, well, my understanding is that DFS was covered. The change that DCI and Byron Odekoven with the Wyoming Sheriffs and Chiefs Association. I asked the House Judiciary Committee, was on page 9 at the very top, beginning on line 2. We were just restoring the law as it reads right now. And so that was restoring some of the physical descriptors that were stricken in the committee draft. And the main reason behind that is the committee might be aware that the Division of Criminal Investigation and my office, Division of Victim Services, are working quite robustly on missing persons in our state. And this came to our attention that if we have a juvenile, which do make up a large portion of missing people in our state, that we might want some physical descriptors and able to find them. Heaven forbid if they went missing, and certainly if they were found deceased. And so that was really just restoring the original law. Can't really recall why it was stricken necessarily. It might have been a recommendation by machine, but we did find it was helpful, and the House Judiciary agreed. And so that is what you'll see. The big change, and my screen is only half loading. There we go. Was page 10, beginning on line 15. You'll see that that entire paragraph was stricken in the engrossed copy. And I can't really speak to that, but I believe that was, again, conversations with Ms. Schilling at DFS and individuals behind the bill. If you move to page 11, which gets a little wonky because we struck that whole position and it's renumbered, but I believe those are, nothing has substantially changed in that section. 12, you will see that Director Schmidt already addressed the rule-making promulgation, and that was really where you'll find that. And with that, that's really the only changes that I thought worth meriting, since we did ask for that change. And with that, I can stand for questions. I can explain some of the things about criminal justice data collection, but again, mostly for the adult system. But again, I'd stand for any questions.
Ms. Chambers, thank you. Thanks for bringing those changes to our attention. Questions for Ms. Chambers? Senator French?
Thank you, Madam Chair. So overall, when all this information is collected, what's the end result? You get all this data, then what? Does it open the door to something else nationally that, oh my gosh, look at Wyoming, they're radioing car, whatever. You can tell I'm a little suspect here, so help me out.
Ms. Chambers?
Madam Chairman, Senator French. So let me preface this that I'm going to speak for the Criminal Justice Information System, which is dealing with adult systems. So in the adult system, we collect it for a variety of criminal justice purposes, not only to, yes, be in compliance with our federal funding, our state funding. We are very data-driven. Data tends to drive funding. But information that's released from the Criminal Justice Information System is de-identified and aggregated. So we're looking at numbers. And yes, it does sometimes result in Wyoming being on the naughty list. I believe that's why this bill is here, because we're on the naughty list for disproportionate rate of detaining of juveniles. But what I actually believe this bill will illuminate is that it's not necessarily that we're just, incarcerating juveniles. It's that we perhaps need to put resources into community-based services. If you recall, there was another interim bill in front of you that hasn't moved forward about addressing, like maybe rethinking our juvenile justice system and how we do this. But generally I happen to be a proponent of collecting data because I think it helps us see a picture. I know in the victim services world, I need to put energy at the crimes that are occurring most disproportionately in our state, and that happens to be domestic violence and child sexual abuse and child physical abuse. So I know that that's where resources should go and attention should be paid and maybe policy should be looked at. So I don't think there's a nefarious purpose behind this. Again, I can't emphasize enough how protected juvenile data is, and so I have no concerns with that. And adult data is also protected to a certain degree. It's not just disseminated willy-nilly, but we do like to look at numbers, and the Division of Criminal Investigation creates an annual Crime in Wyoming report that is de-aggregated data to give people a sense of what's going on in our state and our communities.
Senator French?
One last thing, Madam Chair. Does it open the state up to any federal actions if they say, using your words, Wyoming's been kind of naughty on a few things here? What does it potentially open us up to?
Ms.
If
Chambers?
you have any idea.
Chairman Endercut, Senator French, nothing this doesn't change anything from yesterday to tomorrow, so.
Senator Kolb?
Thank you, Madam Chairwoman. So to summarize, this is merely data that we currently have. It is accessible if you were going to take the time to find it all and to we're putting it into one report.
Chairman Endercut, Senator Kolb, yes and no. If you recall, this is changing a 20-year-old law where the Division of Criminal Investigation was charged with collecting this data and never did. So it's a bit of a loaded question, but no, it's not changing anything drastically. In fact, I think this is a vast improvement to how things are done in juvenile justice in Wyoming. And you're right, it will enable the Department of Family Services to collect, to report aggregate data to bodies like yourself, which was the original request.
So, Ms. Chambers, we are shifting the responsibility to a more responsible agency. Is that
Apparently.
fair?
Yes, she was real excited when I suggested that too.
And Ms. Chambers, so there was a law on the books for 20 years, correct?
Yes.
That required multiple state agencies to provide juvenile justice data, and they failed to do so. Is that true?
Yes, I see that Elisa Butler's here. If she would like to also get run over by the bus,
Sure.
that would be great.
And so when we received the allegation from news media sources doing articles based on anecdotal stories of juveniles getting lost in the system and their lives are ruined, and that we incarcerate at a higher rate, the Joint Judiciary Committee decided to take that up really in response to those statewide concerns. And when asked to receive the information associated with the percent, with our incarceration rates or other types of juvenile related interactions with our criminal justice system, there was none. And so this bill is probably one of the most important bills that come out of our interim, is in response to that failure to have that meaningful data to respond to some of those allegations. You also heard, or you might recall, that there was kind of resistance to us doing anything more in order to allow for a little bit of time to develop or to pass for all of these new systems to come online, including e-filing and all of the electronic systems with our courts, to allow for easier access to some of this information. And so before we overreacted or underreacted, kind of allow for a little bit more time for us to get more of that data. Good question, Senator French. I think concern about are the feds going to come in and shut us down? And the answer is no. I mean, the data really is for us to understand, are our youth in this, I do know from my years of experience on here that there was one particular county, Sweetwater County, that incarcerated juveniles at a higher rate. And I recognize that the term incarceration is not the proper term either in the juvenile world. We all get that, but I don't know that the public necessarily does. And so if we're all talking about the same thing, I think that's helpful. And so our state schools, the boys' school and the girls' school, the highest rate of placements into those came out of Sweetwater County. Why is that occurring? Does Sweetwater County have a unique challenge? It was overwhelmingly higher. So even though Laramie County has tripled the population, we weren't sending our youth to those schools at the same level as Sweetwater County. That doesn't necessarily mean anything wrong is occurring, right? But we don't know, right? We don't really have additional information to help us guide that or to intervene if necessary. So hopefully, this will allow us to make more thoughtful decisions. At least that's my hope. Further questions from the committee? Senator Kolb, in response to Sweetwater County?
Sweetwater County has been thrown under the bus and backed over many times here. I will just say, anecdotal comment, that after changing a district judge, our numbers have plummeted, and I'll leave it at that. Thank you.
Senator French.
Good defense, Mr. Kolb. Thank you, Madam Chair. This data that's collected in on that youth that's 14 years old, and they become an adult and straighten their lives up, blah, blah, blah. Is that data erased from the system?
Chairman Endicott, Senator French, I believe that is addressed, if I recall. No, you're fine, you're fine.
It is.
It is, I just can't find it right away. Is it on page 10? Is it on page? the engr-
12, I think 12 lines.
I don't have the
8
engrossed
through
printed out.
10.
Yeah.
So if we look at paragraph B on page 12, the department may by rule promulgate a process in which, when a subject reaches the age of majority, all information in the juvenile justice information system pertaining to that subject can be preserved in a manner to avoid identification of an individual subject while still allowing for longitudinal data analysis of recidivism.
Thank you, Chairman Undercut. Senator French, and I believe that is, again, best practice for the Department of Family Services, but I could let them speak to that. Again, so we can have robust data collection and analysis over the years. If we simply delete it as was suggested, that would be perhaps problematic down the road.
And Ms. Chambers, to my recollection, to any other practitioner in the room also, for the public circuit court conviction or interaction with the court system, that was always public, right? It was always on file with the court, never confidential. Can that juvenile have their record expunged? And the answer is yes, and we actually created a process a couple years ago that allowed kind of for the automatic expungement of that record at the initiation of the county attorney, and of course, the juvenile can also move for expungement as well. So there's many legal processes in place to protect that record and to have it expunged, removed, de-identified. The juvenile justice system is very much concerned with ensuring that youth don't become labeled and have that continue throughout their lives in a way that is not in their best interest. So I think there's many other avenues.
Thank you, Madam Chairwoman. And at that time.
Seeing no
that-
help in the room.
yeah, No, you're fine. Yeah, DCI does not hold on any juvenile justice data. At that time, we addressed that same issue, that we don't have any, and we're directed to, it was a very strong language, I can't, destroy or disseminate or whatever we were.
Yeah. All right, further questions? All right, seeing none, further public comment? Anybody online? Again, I don't know if you're raising your hand if you're online. I can't see you raising your hand, and I don't know who is currently online. The time is also 8:58. Just a point of notification for those watching this video later. All right. Public comment is closed. Committee, back to you. Moved by Senator Cost. Seconded by Senator Kolb. Any amendments to the bill? Not going to work it like the House? And I'm kidding. I'm really kidding. Okay, Senator Kolb?
Madam Chair, unsure of what we do when we get a bill that's been engrossed and there's been changes to the said bill that we worked on during the interim, and what would be appropriate to do once we know that the House has done this, anything, or should we just let it go on the floor and amend it there?
It already has been amended, so we don't have to make those amendments. The bill, the engrossed bill is the bill. If we don't like those amendments as a committee, how they changed it, we can amend those out. So it appears the House did good work over there. And so I would not suggest that. But the bill is essentially for purposes of you presenting it on the floor. You don't have to present any amendments.
Then I would just like to make a statement about this bill.
Sure.
I think for the audience and people listening on over the internet, this is the cornerstone of a data collection issue that we faced when we didn't have really any aggregated information to know what to do about the juvenile justice system. There was noncompliance with current statutes, shockingly, and we didn't get the data. And this is an attempt to rectify that problem. And frankly, for all the juvenile justice issues we're going to face in the future, we need this data. And that's why I'm in favor of it. Thank you, Madam Chair.
All right, further comments or discussion from the committee? All right, seeing none, roll call vote.
Senator Cooper.
Aye.
Senator French. Senator Kolb.
Aye.
Senator Cost.
Aye.
Chairwoman Nethercott.
Aye.
Madam Chair, House Bill 37 engrossed passes with 5 ayes.
All right, thank you. With that, committee members, we will go to House Bill number 86, Genetic Data Privacy Amendments. I see the chairman, the Senate Chairman of the Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology. Again, as a reminder, I serve on that committee, and this is some of the work that we did in the interim. Welcome, Senator Rothfuss.
Thank you, Madam Chairman. I appreciate it. Good to see everyone, committee. Genetic data privacy amendments is legislation that we worked pretty extensively and had a lot of good, I think, stakeholder feedback on. The legislation is an amendment to our existing Genetic Data Privacy Act, which we put into place around 8 years ago at this point in time. That was work done through a Digital Information Privacy Task Force in the legislature. And at the time it was passed, it was probably the best genetic data privacy legislation in the country. But times have changed rather significantly, and so a lot of other states have passed us, and there are best practices and better language that are in place that have led to the necessity for this bill, where we can once again move into a position where we have the best privacy practices and protections in place as a state. A lot of what this addresses specifically is direct-to-consumer genetic data testing. So those are products that you're familiar with that you can purchase and do your genetic analysis, and it provides protections for the data that comes from that. There is federal law in place. GINA is what it's referred to as, which is genetic privacy at the federal level, but there are some loopholes to that. It provides good protections for things like healthcare providers releasing that data or selling to insurance companies, but there are entities that you can sell that data to and still be legal under the federal law, for example, long-term care insurance providers. So some of those concepts are addressed in this bill, and I think we started with some model legislation, which was kind of the best that was moving around the country. We integrated it with our previous best practices so we don't lose anything, but we effectively gain additional protections and clarifying language, Madam Chairman. With that, and I can go as deeply or high level as you feel like, Madam Chairman, so please feel free to adjust me on the fly, but I'll try and keep it relatively medium level as we go through, and we'll see how it turns out.
That's just right for Goldilocks.
Yeah, I'm going to try Goldilocks on this if I can. So, Madam Chairman, it begins by creating some additional general limitations, which you can see on page 2, some new statute, and then everything else is effectively going into existing statute, but providing upgrades to it. And oddly enough, you'll see that 3532-105, while it's at the beginning of the bill, comes at the end of the Genetic Data Privacy Act, which is why it seems a little bit awkward. But you can see that the discussion here, which we'll see in a moment, is that the provisions of the chapter applicable to direct data consumer testing companies shall not be waived. This is a key concept. So you cannot waive your right through the minutia of confusing contracts, which was a best practice. And some disclosure language saying basically that what you see in B is pursuant to federal law, where you have HIPAA or HHS or other federal statutes in place. Compliance with those shall be effectively sufficient compliance, which regrettably we have to do. I'd rather be stronger, but we struggle to achieve supremacy over the feds. With that, on page 3, a lot of what's done here is some additional definitions and changes to definitions where we already have definitions on the books, but we're conforming to the best definitions available. And there was an interest in creating uniform definitions among the states. So these definitions truly are better than the definitions we had, and a lot of that was conformance. You see some details of genetic testing, genetic data, and again, we can go into it in more detail if you'd like, but those are scientifically accurate and best practice definitions that are consistent with what other states are using. On page 4, we already have informed consent, but there's just some variation in conforming amendments to ensure that it's compliant with the above definitions. Page 5 is a new definition, which is coming in about biological sample. And you'll see consumer means a natural person who is a resident of the state of Wyoming. This comes into play elsewhere where we're talking about consumer data testing. And a natural person, as you'll all recall, really does mean a human individual as opposed to what we talk about when we say person or individual. being a little more confusing, and it's a resident of the state of Wyoming, so the protections that we take on are protections for residents. De-identified data you were actually just discussing with the previous legislation. On to page 6, Romanet 10, direct-to-consumer genetic testing company or company. There's a lot of additional requirements for them that you'll see in this bill that were brought through that model legislation by those entities. And express consent this is important, means a consumer's affirmative response to a clear, meaningful, and prominent notice regarding the collection, use, or disclosure of the consumer's genetic data for a specific purpose.
Senator,
Yes, go ahead.
just to kind of refocus,
Mhm.
the application of this, as the judicial committee, we frequently just see it in the judicial realm of things, but this concern is much, much broader, and quite commonly we see this with the use of companies like 23andMe or Ancestry.com, where you want to submit your DNA through them. And so really this bill is kind of intending to address the broader consumer application of this and is not limited to the judicial application. In fact, really has nothing to do with it in this bill. Fair?
Yeah, Madam Chairman, that's accurate. And in fact, our previous legislation kind of tried to get into judicial and state use and had already drawn most of those lines, and this doesn't change that. It is very specifically oriented towards these direct-to-consumer uses where you've given an entity, a private business, your genetic data. They're going to provide some analysis for you. What happens next? And this provides substantial protections for it, and they're very rigorous. And I was actually happy that the model legislation was as strong as it was. So we'll have the opportunity to hear from, I believe, those companies later. I think they're available for public testimony, Madam Chairman. So that's the core concept, is this idea of direct-to-consumer. Bottom of page 6 and 7, it's conforming amendments based on the new definitions. Page 8 is the beginning of this C paragraph, which is quite long and has a lot of provisions. This is effectively the model legislation that is specific to the privacy, confidentiality, security, and integrity of a consumer's genetic data. A direct-to-consumer genetic testing company shall. And then you see quite a few details about providing clear and complete information regarding the company's policies and procedures. That includes a high-level privacy policy overview of essential information, prominent publicly available privacy notices. You see in the Romanet 2, obtain a consumer's consent for the collection, use, or disclosure that at a minimum on 9 includes initial express consent. And you'll see the definition of express consent is explicit. It has to be meaningful, as we mentioned before. It can't just be the, I scrolled to the bottom of the terms of use and clicked on OK. It has to be specific and direct. You see separate express consent for transferring or disclosing the consumer's genetic data, separate express consent for the retention of any biological sample, informed consent in compliance with federal law for disclosure to third-party persons for research purposes. And that's a key point. There's federal law that governs how to use genetic data for research purposes. This makes it very clear that if you're going to put yourself in that category, you have to give separate express consent to put yourself in the category, because then federal law is going to preempt, and there's a lot that you can't do from that point forward effectively. Once you put yourself into those research trials, different statute will govern, so it makes it clear. Page 10, the E paragraph, separate express consent for marketing to a consumer based on the consumer's genetic data. Then into Romanet 3, require valid legal process for disclosing genetic data to law enforcement.
Senator, here, separate express consent for marketing to a consumer based on the consumer's genetic data. Can you give us an example of what this looks like in real life?
So you could imagine a circumstance, for example, where you show up in one of these testing procedures, perhaps as having a certain predisposition or condition genetically. Perhaps you could opt in at that point to receive information, marketing materials about drugs that might treat that, or about clinical trials that might address that particular concern. Alternatively, if you're getting to the ancestry side of things, you've submitted your data to a company that looks at your genealogy, you might get marketing material associated with that genealogical information, whether that's specifically relevant to your data or even just more generally relevant at that point in time.
I'm aware too, Senator, that there's new companies that you could submit samples and they'll tell you what what diets would be best for you and different types of food choices and different
Good
types of
examples.
exercise plans and those types of things.
Absolutely, very good examples. Yeah, so anything that's linked to your genetic predispositions or history could be useful to you. You could opt in and want the marketing material. And you can opt out again for almost all of these things, except for, again, federal research. Opting out is a challenge. That's not to say you can't opt out on the website for additional trials, but once you've provided data to a clinical trial or for federal research, then you are governed thereafter by the federal requirements and regulations, which basically means that they're going to keep anonymized data and handle it under standard federal practices. Can't pull back from that. Romanet 4, develop, implement, and maintain a comprehensive security program that protects a consumer's genetic data against unauthorized access, use, or disclosure. So this is a nice standard which basically indicates, without being too specific, that you have to protect the data rigorously and that you have an obligation to do so.
And Senator, on this, is there a concern that foreign countries might be trying to get that data?
Yes, yes, there is.
All right, so this is a very important bill.
It is,
All right,
absolutely.
keep going, Senator.
It's this is really a pretty darn good bill, honestly, and we won't take claim of authorship over it. A lot of people have worked on this, but I think it's an excellent bill. Provide a process for a consumer 2 on 10 onto 11. This is consistent with common themes on best practices for information at this point. You can see that you would have a right and procedure to access the consumer's genetic data, to delete the consumer's account and genetic data, and to request and obtain the destruction of the consumer's biological sample. So that continues, and remember, you can't waive those rights. Very, very good, very rigorous standard so that you will continue to maintain authority over your genetic material, and that's critical. The D paragraph, this is something that honestly is unique to Wyoming, where we added a little additional level. This gets back at what I mentioned about GINA, which is the federal protections that exclude a standard health insurance company from receiving or requesting your genetic information and then making decisions based on that, which is great, good policy in GINA, but it only covers standard health insurance. It doesn't cover life insurance or long-term care insurance or an employer's right to access it. So we are adding additional provisions of protection that have commonly been criticisms of GINA to ours to ensure that we've added that additional layers. So you see here, notwithstanding any other provisions in this section, a direct-to-consumer genetic testing company shall not disclose a consumer's genetic data to any entity offering health insurance, life insurance, or long-term care insurance, or to any employer of the consumer without the consumer's written consent. So that would be a higher level of protection than what you see elsewhere. Bottom of page 11 is conforming to definitions. All of page 12 is conforming to updated definitions. Page 13. This is some new language where there's concern about bringing action based on inaccuracies through the courts. We already had in statute what you see as the existing language there, which provides some protection. There was interest by industry to specifically have a time for cure, which is if you've made a request and that's not being followed through, or you have concerns about the request, that instead of going immediately to the courts and filing action, industry wants the ability to have a 60-day time frame to cure the violation. In other words, make a request first, hey, fix this. And after 60 days, if it's not fixed, then go to the courts. And so it doesn't deny access to the courts in any way. It just says, give an opportunity before filing a massive class action suit or on your own behalf to at least allow an opportunity to fix the transgression, which is quite honestly pretty fair. And it, again, doesn't take back if there was negligence or anything along those lines, you're still going to have your court standing. And then you can see the C paragraph provides the Attorney General with opportunity to bring action on behalf of the state or on behalf of consumers to enforce the chapter and provide some provisions for the penalty. So I'll stop there and happy to answer any questions, Madam Chairman.
Senator Kolb.
Thank you, Madam Chairman. Good morning, Senator Rothfuss. Particularly, I didn't hear this touched upon, and it may be in the bill, law enforcement, their access to your genetic information. And I'll say for the record, it's too late for Senator Kolb. I've already got mine done, so this will not afford me any protections. But I just wondered how that would work if they do data mining, if I can phrase it like that, with your DNA information to track down certain people. Is there anything contemplated in here or protections?
Are we going to catch the Golden State Killer, Senator Rothfuss?
Well, Madam Chairman, and you'll hear from the industry if you ask the same question, that their process and standard is pretty straightforward. If you've got a specific warrant to a specific case, they will disclose to you the necessary information. And apparently they've never done that. They will not allow fishing expedition warrants. And the only thing that this provides for is it's on page 8.
And Senator Rothfuss,
Yes, go ahead.
isn't it true that oftentimes law enforcement goes about it in a different way, which would be lawfully, where they have a suspect, they just can't prove it. They have a DNA sample, which they can't get potentially, and so they find a family member. And then they get a consensual DNA sample from that family member.
Correct.
Who then submits it.
And Madam Chairman and Senator Kolb, what you don't see here is the rest of the Genetic Information Privacy Act that we had before, because this is the new material or changes that are going into these direct-to-consumer applications, which really weren't that big of a deal as they are now when we created it for the first time. And we made it very clear that law enforcement is going to have standard law enforcement investigatory authority. Nothing really changed with that. The only thing that it really says in there is you can only use it for the purpose. If you're under an exception, you can only use it for the purpose of that exception, and you can't use it for any additional purposes or transfer it. And that once you're done with it, you should destroy the sample effectively. Now, for law enforcement, done with it is probably a different threshold and standard than what done with it might be for a paternity test, as an example, which is also allowed under statute, that you can get somebody's genetic information for a paternity test. Once you're done with that paternity test, the state would be obligated to destroy the sample. So that's already existing statute. And other than say that so this is page 10, Romanet 3 on line 14, require valid legal process for disclosing genetic data to law enforcement or any other government agency without a consumer's express written consent, So require a valid legal process. And this doesn't provide for what that is. That is then up to elsewhere in the state and whatever is in existing statute for appropriate use of warrants.
Follow-up? Yes.
And for myself and the audience, the definition of a natural person, why does the word natural need to be there, and what does it really
What page
help?
are you on?
Page 5, line 7.
That is in statute how we describe what in any other circumstance we would simply call a person. But due to case law and due to definitions elsewhere in statute, a person also means a business or a corporation or other types of entities. There are a diversity of things that qualify as a person. So in statute, when we want to say what we traditionally think of as a person, which would be you or me or Chairwoman Nethercott, we say natural person.
Further questions? Senator French.
Thank you, Madam Chair. Senator, a lot of communities, I think they do it across the entire state, community blood draws. You can request whatever test you want or numerous tests, how do you know that the outfit that's doing that hasn't kept the record or the DNA sample or whatever? How does a person know? Because a lot of people do it every year to keep track of their health, you know. How do you know that that's gone?
Senator, if you
Madam
know.
Chairman, Senator, enforcement's a challenge. That we don't have any genetic police running around trying to make sure nobody's keeping samples. So the reality is, this is providing what is the appropriate legal framework that you should be operating under the assumption that most people will operate under the appropriate implementation. If it's determined that somebody's violating that, there are certainly penalty clauses here. But as to how we would know if somebody was violating it, that would be a challenging thing to find out realistically. I mean, you know, they'd have a refrigerator full of vials. You're not going to be able to figure it out very easily. It's true. So it's one of those situations where we're putting a legal framework in place with the expectation that it will mostly be followed to a high level, and we know that the good actors will be following it. That'll give us confidence in the good actors, but there's certainly nothing that says that if somebody collects that blood sample, they can't save it in the freezer if they just for some reason want to.
Any questions, any final questions? All right, with that, we're going to go to public comment. Mr. Pickard? And is there anyone else in the room that wants to speak to this bill? We have someone online too, and if you could bring them in as well right now.
Good morning, Madam Chairman, members of the committee. My name is Dave Pickard. I represent Ancestry and 23andMe. And I'm going to turn most of my testimony over to Mr. Engelhardt, who's on the Zoom. But I do want to address a couple of the questions that came up and then share an experience. Members of the committee, when Ancestry and 23andMe came to me late in, I think, the month of September to talk about updating our laws, what we're really looking at is the evolution of direct-to-consumer activities out in the marketplace. And I was a little bit familiar with the bill. I worked on it with Senator Rothfuss back in 2018 on a very minor amendment. And Wyoming was cutting edge in data privacy back there, and in particular in genetic data privacy. And so in this ensuing years, a couple years ago, I think actually it might have been last year, the state of Texas legislature was taking up genetic privacy legislation, and they were referencing some of Wyoming's definitions. And the companies looked at this and said, my gosh, where is this coming from? Since ours had been on the books for many years, and again was the leading state to go into this privacy matter, they kind of reverse looked at everything and said, it's coming from Wyoming. So let's go in and take a look at Wyoming and update their definitions. And that's what you see the beginning of the bill doing. And then throughout that process, personal note, I did not know my background. I did not know my origins. So I signed up for both of the direct-to-consumer companies that I represent, provided my sample. And when you're going through that, you agree to some consents before you, or when you sign up. They sent you a test kit. You provide the sample. In this case, it's a saliva sample, very simple. And you send it back in. When you get your results, you go through, again, on the website and go through all of the consents. And I looked at it from a view of a legislator, because I had been in the conversation at one of the blockchain committees when we presented the concepts of the consents. And I went through and it's like, I wanted to see if what we're doing in legislation is manageable from a consumer perspective. And it certainly was. Very clear cut. Both of the companies, very similar in nature. They pull up all of the consents. It's not like Senator Rothfuss said, going all the way down to the bottom and clicking, I consent. We do that on banking all the time. We do that on on a whole variety of websites, but this one is very clear because they are dealing with your, DNA, your being of evidence, basically. So it was very fascinating. Ironically, I was kind of surprised, but also intrigued. I'm 57% Norwegian, 20% Northwestern Europe, 14% Swedish, 7% Wales, and 2% Germanic Europe.
And we are shocked.
So it was really fun to see. Madam Chairman, I'm going to turn it over to Mr. Engelhardt, but I appreciated the comments. Yours in particular on the marketing consent, he will address that. Foreign access, that was a question that came up on the House side. Very, very important. He will address that. Who they share data with. And then the Golden State Killer, also talk about the GenMatch site, which is not a direct-to-consumer company. And then Senator French, your last comment and concern about blood draws. I would draw your attention to HIPAA. That is in that realm, the Wyoming health fairs that do blood draws, they're not doing DNA testing. They're utilizing those blood samples to take a look at your cholesterol, your other CBC panels and all of that, and that would all fall under HIPAA. And there's also protections in our state laws under HIPAA as well. So with that, Madam Chairman, if there's any questions, I will certainly try and answer them, but Richie's the expert.
All right, with that, let's go to Mr. Engelhardt. Good to see you, Mr. Engelhardt, again. Welcome to Senate Judiciary Committee. If you would introduce yourself to the committee, who you're with, and share with us your thoughts.
Thank you, Madam Chairwoman and members of the committee. My name is Richie Engelhardt, and I'm the head of government affairs with Ancestry. Here today includes 23andMe. We want to thank you for giving us time to speak this morning about HB 86, proposed legislation to update the 2018 Wyoming Genetic Information Privacy Act. A lot's happened since that bill's enactment. Later in 2018, the Future of Privacy Forum published the Privacy Best Practices for Consumer Genetic Testing Services, capping off extensive work with industry partners, consumer and privacy advocates, key committees on the Hill in DC, and the Federal Trade Commission. Since then, other states have taken an active interest in protecting consumer genetic data. Our companies have worked with lawmakers on both sides of the aisle to translate the best practices into legislation. That bill has enjoyed bipartisan support in Arizona, California, and Utah, with both industry and consumer advocates aligned. And without going into too much detail, as Senator Rothfuss did a great job, HB 86 builds on the work that began here in 2018, where the original Wyoming statute focused on consent for obtaining, analyzing, retaining, or disclosing genetic information. The bill before you also ensures consumers have easy to understand information about our company's policies, more control over how their genetic data is used, and the bill would conform the definitions in Wyoming statute to industry standards, further strengthening protections for consumers. If passed, Wyoming will have the strongest protections for genetic data privacy in statute. And by putting these protections into law, the bill will ensure that every direct-to-consumer genetic testing service is held to the same standards we've set for privacy and data protection. I especially want to thank Chairwoman Nethercott and the rest of the members of the Committee on Blockchain for the work undertaken during the interim. It was a pleasure working with everyone, and we appreciated the careful consideration given the bill. Address a few of the questions that Dave teed up on law enforcement access. As noted, this bill requires a valid legal process before a company would disclose any genetic information to law enforcement. When you look at what happened with the Golden State Killer case, that was done using a website called GenMatch, where consumers download their ancestry or 23andMe, upload it to GenMatch so that they can see their matches across all platforms. Of service. Once the Golden State Killer case broke, privacy advocates went a little bit haywire, rightfully so, because that's something they felt that consumers should have to provide an express consent in, not just opt out. So GenMatch is now opt-in. So the only databases that law enforcement is using for forensic genealogy searches are data has opted in for that purpose. That's not a service that Ancestry or 23andMe provides. We're actually not interested in providing that service. We've got a closed loop ecosystem, and ours is very focused on genealogy. But there are places where consumers, if they want to participate in those law enforcement investigations, can do so. under this law, they would have to provide consent, which we believe is the appropriate standard. Dave correctly noted that anything done in the clinical setting, like a blood draw for a community health event, would be governed by HIPAA, and HIPAA has very stringent privacy rules in place as to what needs to be done with sample retention and protection of consumer data or patient data. And on the foreign access issue, we've got a lot of scrutiny at the federal level. Ancestry was acquired by a US company, private equity firm last year. And even in the context of being acquired as an American company by an American private equity firm, we had to clear basically a review by CFIUS, which is the Committee on Foreign Investment in the US. And we had to make commitments about where we do and do not send data for analysis. So all of our samples are processed in the US. We in China, we don't market in China, we don't offer our services there, and we don't do any of the sample analysis. So everything is kept here domestically, and we have no plans to go into the Chinese market because as there are concerns with this committee about their behavior in respect to IP, we have those same concerns, and it's just not a risk that we're willing to take.
Mr. Engelhardt, thank you so much. Helpful comments. Thank you for being addressing all of those questions and being so brief. Questions from the committee? Would you like to know your ancestry right now? All right, seeing no questions. Mr. Engelhardt, thanks for being here with us this morning. And I know you were hanging in there for quite a while. So we appreciate your time and interest in this bill and helping us make good legislation for the people of Wyoming.
Thank you so much.
All right, any final questions for Mr. Pickard? All right, seeing none, further public comment on this bill? An uncomfortable delay. Public comment is closed. All right, moved by Senator Cost. Is there a second? Seconded by Senator Kolb. Amendments to the bill? Seeing none, roll call vote.
Senator Cooper. Senator French.
Aye.
Senator Cole.
Aye.
Senator Cost.
Aye.
Chairwoman Nethercott.
Aye.
Madam Chair, House Bill 86 passes with 5 ayes.
All right, thank you. And with that, the time is 9:33 a.m., committee members, so we have about 20 minutes to work this bill. This is, again, a joint Judiciary Committee bill, Supreme Court Justices and District Court Judges Retirement, House Joint Resolution 1. This did pass through the House already, as you can see here, and it is unamended, which is why you only see a white version of the bill. I do see Ms. Butler in the room. So Ms. Butler, if you would like to join us this morning from the Supreme Court. And I will briefly just go over the bill. We are changing the age of when our judges are being forced to retire from 70 to 75 years. So Ms. Butler, welcome.
Madam Chairwoman, members of the committee, good morning. My name is Elisa Butler. I am the State Court Administrator at the Wyoming Supreme Court. The Judiciary is in support of this bill. As the good chairwoman indicated, what it would do is it would allow our judges, our district court judges and Supreme Court justices to serve 5 more years before they are required to retire as judges or justices. So it is a constitutional amendment, so we'll need to go to the voters, but that's just broad overview.
Questions from the committee? Senator French.
Thank you, Madam Chair. Forgive me, I just put a cough drop in. I realize people are living longer and healthier due to our health system and blah, blah, blah. Is there any safeguard? How do I say this? If this passes and a judge is 72 years old or whatever age, under 75, and they begin to have health issues that maybe they don't realize, but others may realize in the system, is there anyone that would say, okay, this judge is really not up to par. Is there a safeguard, I guess is what I'm looking for. Thank
Ms.
you.
Butler?
Madam Chairwoman, Senator French, there is. So the judges are bound by ethical standards, and one of those is to be able to basically serve as a judge, have the mental and physical capacity to serve as a judge, and that is governed by the Commission on Judicial Conduct and Ethics. And so if there was an issue with a judge's performance, there is a safeguard there to go through that commission and hopefully appropriately deal with the issue that they're having.
Any further questions from Ms. Butler? Any conflicts of interest on the committee?
Madam Chair?
Yeah, because two of us are older.
Two of you might feel some empathy for the 70-year-old judges, that's all. Perhaps we should make a same provision for legislators, huh? No? All right, all right.
Thank you.
All right, thanks, Ms. Butler. All right, further questions from the committee? All right, seeing none, roll call vote.
Senator Cooper,
Yeah, right.
Senator French, Senator Kolb,
No.
Senator Cost,
Aye.
Chairwoman Nethercott.
Aye.
Madam Chair, House HJ 1 passes with 4 ayes and 1 no.
All right, committee, great work this morning. The meeting is adjourned.